Can you be held legally responsible for the mistakes or wrongs of your real estate agent under California law? The answer is yes. Yes, you can. And when I say real estate agent, I also mean real estate broker. Real estate agent should be working under a licensed real estate broker. So there's a legal doctrine in California called respondent superior, which basically means the master is responsible for the actions of the servants. And in our modern era, that means that you, as the principal or the client, can be held responsible for the bad actions of your agent, and that would include your real estate agent. So what they call vicarious liability can be created by the actions of a person's agent, right? And that can be very serious. So a buyer or a seller, either one, can be liable for the mistakes or wrongs of the real estate agent. Now, what do I mean when I say mistakes or wrongs? So I'm going to break that into two categories. So a mistake is an honest error that's made without the intention, let's say, to defraud, okay, but it's still a mistake. So an example would be your real estate agent lists your house as 1,800 square feet when it's only 1,200 square feet, but it was an accident. They didn't do it on purpose. Okay, that's an example of a mistake. A wrong is when your real estate agent is intentionally deceiving people, right? So withholding information or providing false information. Okay, and in either case, you can be held civilly liable for the misrepresentations made by your agent. So you usually can't be held criminally liable if you didn't know what was going on, but you can be held civilly liable. And that's true even if your real estate agent or broker makes a mistake without your knowledge or commits a wrong without your knowledge. So, for example, you real estate agent tells a buyer that your parcel can be subdivided under the current zoning, and you have no idea that conversation happens, right? But the real estate agent says that, he or she didn't really check those facts. Turns out that you can't subdivide the parcel under the current zoning. The buyer could turn around and sue you for the misrepresentation that's made by your agent. So that's a pretty serious deal. There's examples in California case law, court decisions that exact circumstance where people have been sued because the agent said that a parcel could be subdivided under the current zoning and it can't. I'll give you another example. This is an actual case that happened in California. A real estate broker falsified apartment leases, made the leases appear that they were for longer than they really were, and that they were for more monthly rent than they actually were when he was trying to sell an apartment complex. And the lady that bought the apartment complex found out about this and then sued the seller based on those misrepresentations. And the seller went to court and argued that he didn't know what the real estate agent was doing. He wasn't aware of it. And the California court said, too bad, so sad. That was your agent. You should have hired an honest agent, and we're going to hold you responsible for the mistakes that your agent made. So why is this important? Well, it's important because you want to hire an honest broker, right? If you don't hire an honest real estate broker or real estate agent, and something fishy happens, or even if something just a mistake's made, they're incompetent, you can be held civilly liable in a California court of law. That's why it's so important to hire a good real estate broker, real estate professional. Make sure that they're going to do a good job, that they're going to represent your interests, and that they're going to be honest, not only with you, but also with your buyer.